Hello, everyone. I'm Alex Boissonneau-Lehner. I'm an employment lawyer here at KMB Law, and you can find our contact information on our website, www.kmblaw.com. At the end of this video, we'll also post our individual contact information so that you can get in touch with us individually. And today, I am joined by Rosalie Springer. Hey, Rosalie.
Hi, how are you doing?
I'm doing all right. How about you?
I'm okay. Given that I'm also working as an employment lawyer at KMB Law with Alex and our head of our department, Jonathan Borelli, who couldn't be with us today, we are inundated with a lot of work and, trying to think on our toes given this unprecedented situation. And I really would like to say that if someone says the word unprecedented one more time after the pandemic ends, I'm going to lose it. Because really, it is just the most hot word that's been used these days. And in fact, it's true. We are in a new time that we haven't been prepared for. The courts haven't been prepared for it. The legislation isn't prepared. Lawyers aren't prepared. We are now really thinking and adapting on our toes, I would say more than ever before, at least in my years of practice. And we're coming up with new solutions and really interpreting issues in the moment and advising our employers accordingly. And it's just, I'm tired. How are you dealing with this yourself?
Well, I still have a bit of energy. I have my energy drink here. That's keeping me powering through. But yeah, it's an interesting place to be as a lawyer because we're very comfortable living in precedent, and it is a unprecedented situation. But it's somewhat fun as well to be dealing with kind of new changes and adapting on a almost daily basis and trying to find creative solutions to the problems that our clients are facing during these challenging times.
And in effect, too, we're creating now the precedents. We are moving everything forward and saying, this is how things should be dealt with. Other lawyers are doing the same, and we're now creating, the new situation that's going to move us forward. In case, God forbid this happens again and there's some new pandemic, at least we'll sort of have some tools to look back on.
That's right. Absolutely. So today, we're not going to be talking about something that directly pertains to COVID-19, although we do recognize that COVID-19 has presented unique challenges for employers and their businesses. We're going to talk about actually kind of a new challenge for employers that was created by our courts recently. Unfortunately, the courts have not been providing too much relief for employers, and they have not been terribly kind to employment contracts this summer, particularly termination provisions in employment contracts. So that's going to be the focus of our discussion today. And while we encourage everyone watching to watch our entire video, in the event that you're busy, we're not going to keep you in suspense. So we're going to give you the bottom line up front. Please stay tuned, though, because it's a more involved discussion. Here's the bottom line. Get your employment contracts reviewed by an employment lawyer now. Chances are that the termination provisions in your employment contracts as a result of the court's recent decisions are no longer enforceable. All right, so before we really dive into the recent decisions of the court, particularly the Court of Appeals decision in June of 2020, let's go over some of the basics so that we can understand what this decision is and its impact. So Rosalie, what is a termination clause, and why would an employer want to have one in an employment contract?
So a termination clause essentially is a clause in a contract that sets out the employee's entitlements when their job comes to an end. And it also, for our focus, because we are mainly, now it's shifting a little, but we're mainly counsel for employers, is that it protects the employer and their liability for what they have to pay out on termination. So it limits them from having to pay exorbitant amounts, and it sets expectations and creates, an understanding between the employer and the employee about what's happening at the point that they're terminated.
That's right. sets expectations for both parties.
Yes.
But how can a termination clause specifically protect an employer's interest?
So it can limit the amount of advance notice that an employer has to provide an employee when they're, going to terminate them, or the pay that they would be paying them at termination. So in other words, it really allows employers to save money. When you have this clause in your contract, you are saying, this is what I'm paying you and not a penny more, theoretically, right? As long as there aren't any issues with the clause, right? If the clause is binding, this is really what the employee is entitled to, and that's it. And the employer can then rest easy and save their money and put their hard-earned dollars into other things.
Absolutely. Well, before we talk about what would make a termination provision in a contract binding, I think the question that a lot of employers will be asking is, well, how much money can we save? Is there a dollar figure, or how is that determined?
So really it depends on the Employment Standards Act 2000, which is the governing legislation in employment law in Ontario. And really it is set up to protect the employee's interests. So it has the minimum entitlements that employees are, entitled to receive during their employment. So it sets various standards, and then on termination as well. So if the termination provision is in a contract, it at least must provide for the minimums that the Employment Standards Act outlines for termination specifically. That's what's limited, and there is a formula that the ESA uses to provide on termination, which we'll get to.
I see. Well, what would happen if the contract does not provide for at least the minimum amounts set out in the Employment Standards Act? Or what would happen if the employment contract says nothing about termination?
So in that case, automatically the employee would be entitled to a far more generous termination package. And what the law refers to that as is called common law reasonable notice. And what the amount of that is based on various factors, which we refer to as the Bartle factors. And what that is based on the employee's years of service, position, age, and the availability of similar employment. So really, the longer the service, the more notice. The older the employee, the more notice. The more senior they are, the more notice. The less available opportunities, theoretically, the more notice. That one's a little bit debatable.
Well, let me just jump in there.
Yeah.
I actually think that as a result of the COVID-19
Yes.
crisis, that this availability of similar employment, when the courts are weighing these factors, they're going to accord more weight to that,
Yeah.
if anything. There is the huge economic downturn as a result of this COVID-19 crisis. And for most employees, there simply isn't as much available positions. So I think a court is going to take that into, we don't know, because there hasn't really been any decisions that I know of that have been published, given that the courts are kind of frozen right now, although they did release some decisions, I guess, from hearings previously that relate to termination clauses in the last few months, but they're not really doing new hearings. But I predict, has your lights gone off?
Yeah,
Or energy efficient building?
Yeah.
Well, I'll keep talking, but we predict that the availability of similar employment, and really the lack of availability of similar employment for most employees, will actually have the effect of increasing the notice that is owed to employees, rather than decreasing it or it staying the same. So it's a little tricky to terminate during the COVID-19 crisis if you do not have a enforceable ESA or enforceable termination clause. And the bad news is you most likely do not, even though it may look as if you do. So I'm sorry that I jumped in there, but it gave you the opportunity to turn your lights back on. So Rosalie, maybe to illustrate the concept, can you provide a few examples of what an employee might be entitled to if they're effectively limited to their Employment Standards Act minimums, and what that same employee would get at common law.
So exactly, so I'm happy to do that. So let's consider the example of a mid-level employee who's in their 30s and who is at sort of an average kind of position, and they're terminated after 2 years of employment. So the ESA would say that unless there's an exemption, right, unless that person is in a specific kind of position, and there are, again, exemptions on termination, and we're not getting into that today. That's, for more information on that, please contact us. But, after 2 years of employment under the ESA, the employee will get at least 2 weeks of pay and benefits. And that's, their minimums. If they get benefits, they'd get benefits. At common law, though, as I said, it's a much higher entitlement. And so someone who's worked for 2 years could get up to around 2 months of salary and benefits. So that's that example. Another example, let's say there's...
So roughly 4 times as much, if my math is right.
Yeah.
Even a little more than that.
Yeah, 2 weeks versus 2 months. It's pretty significant.
Right.
So another example would be, now we're looking at someone who's a bit older. They're quite a senior level employee, and they've worked for 30 years of service at the same company. And what the ESA would say is they'd get 8 weeks notice. 8 weeks, unfortunately, it's really, the rule of thumb, the rule for the ESA is it's 1 week per year of service up to a maximum of 8 weeks for termination pay. So this employee would get only 8 weeks for termination pay, which is great for the employer because they worked there for 30 years. And then they would get 8 weeks of benefit continuance, and maybe, depending on the circumstances, they would also be provided with severance pay, and that would be 26 weeks of severance pay, because severance pay is capped at, it's 1 week around per year to a maximum of 26 weeks. So that's about 8 months. But if you were to look at the common law reasonable notice standard, that would be around 2 years of pay, which is, 8 months versus 2 years, very big difference.
Big difference indeed. So again, the default entitlement of an employee is when they are terminated without cause, is their common law notice. But the employment contract can specify a different entitlement so long as it complies with the minimum standards of the ESA. So in that case, that last example, that was kind of an extreme example. You see the difference. It could be as little as 8 weeks termination pay. And if there's severance, then we're looking at 8 weeks plus 26, so I guess 34 weeks, as opposed to more than liability for 2 years of this person's salary and their bonuses and the value of their benefits. It's a huge change. So for the employer's sake, most employers would like to, unless this employee was a fantastic person and the company is doing well, they would prefer to limit their liability closer to that 8 weeks or 8 weeks plus the 26 weeks of severance than they would the payout for 2 years or more. But here's the challenge. Courts tend to interpret employment contracts much more differently than ordinary commercial contracts. And they tend to interpret them in favor of the employee. And why is that? Well, the employment relationship is somewhat unique. Courts have recognized that there's a power imbalance between the employer and the employee. When you think of the party's relative bargaining power, the employee has far less bargaining power when it comes to forming at the beginning of the employment relationship. Essentially, the employer sets the terms, and the employee has the option of taking the job usually or not taking the job. They can't push back too far. So the courts have tried to balance this as they view that the employee is in more need of protection than the employer. Mm-hmm. However, courts are still bound to, they're going to respect the contractual arrangements between parties, but they're going to look at it with a magnifying glass and interpret that the provisions of the employment contract in the case of any ambiguity or any uncertainty. in the favor of the employee. So if the termination clause can be interpreted in more than one way, the courts are going to prefer the interpretation that is more favorable to the employee. Courts tend to approach termination clauses, therefore, with a skepticism, and they are more inclined to look for reasons to find them unenforceable rather than to look for reasons to uphold them. So that's been the trend in the case law over many years. That's not new. That's not unprecedented. In fact, this is how the law existed prior to these decisions that we're going to be talking today. It's sufficient for if a provision of a contract potentially violates the minimum standards of the Employment Standards Act at any date after the hiring. So this is actually a good jump off to talk about one of the two cases that we're going to be covering in this webinar. It's the Ontario Superior Court of Justice's decision that was released only last week, and today is July 15th. But this decision is called Rutledge and Cannon, and it really illustrates this principle. So even though we said earlier we're not going to talk about exceptions to the ESA, we're going to touch upon it just briefly because this case kind of dealt with that issue. So the plaintiff in this case, Rutledge, he was a construction employee. And construction employees, generally, it's a little more nuanced than that, are not automatically entitled to the minimums under the Employment Standards Act when it comes to notice and severance or termination pay. So the employer, Canon, in this case, in their contract, they correctly stated that they wanted to limit the employee to the minimum Employment Standards Act entitlements. So the contract stated that they're going to get their minimum entitlements under the Employment Standards Act, but then the contract went a little further and it clarified that because you're a construction worker and because of the exception, the minimums are nothing. You are actually not entitled to notice or pay. So important to note in this case. When the employee was hired, he was a construction worker. When he was terminated without cause, he was a construction worker. So under the ESA, that is the Employment Standards Act, the employee is not entitled to any notice of termination.
So it does comply with the law. What they did does comply with the law, technically.
Right, it does. But what the court is concerned about is not how it actually played out in fact, but how it looks on the contract. They're interested in interpreting the contract as opposed to how the matter actually played out. So even when there is a potential that the contract could provide for something less than the Employment Standards Act, the court will not enforce the termination provisions and would give the employee their default entitlement, which again is that common law notice.
Yes.
So in this case, this kind of takes it to extreme that I don't believe we've seen in the case law before. So again, the construction worker was hired as a construction employee. There was no indication in the contract that he might not be a construction employee at some point. And when he was terminated, he was a construction employee.
Yeah.
However, the court held that because there was this theoretical possibility that at some point after his hiring, the construction worker could have been transitioned into another role that's not purely construction-based, maybe into the accounting department or something like that, because there's that theoretical possibility that the statement in the contract, which said, as a construction employee, or it's not an exact quote, but the effect of the clause was, you're a construction employee, so we're just setting the expectations. You're not going to get any notice. You're not going to get any termination pay. You're not going to get any severance. You're not going to get any benefit.
So I have a bone to pick with that case. I will make it known that I completely disagree with the decision because
let's hope you never appear before that judge, Rosalie.
I hope so. But
or that she's not
I disagree because in the event, first of all, in the construction industry, usually the positions are quite specific, right? This person is specialized in construction. They won't likely, again, I can never say that a construction worker could not have an accounting degree, but likely they would stay within the realm of construction. So maybe they'd go up to management in the construction industry. Maybe they'd be a construction worker doing some kind of work related to construction. But if it's related to construction, usually, they fall under the exemption. So if on the off chance that they would be promoted to something out of the construction specific field, they usually, if they have an intelligent employment lawyer, the employment lawyer would draft up a new contract with the minimum entitlements they would be entitled to say, now you've entered our accounting department and here are your minimums. So I practically don't think that this makes sense in terms of the decision, because usually like that to me is just too far-fetched of a situation where the construction employee wouldn't be a construction employee at termination. Or if they were, usually a lawyer would, or the company would update the contract to state that now you're no longer a construction employee and these are your entitlements, and they would then have the minimum entitlement. So I think that it's very far-reaching of the court to say, if there's any possibility at any time that he may not be in the construction industry, this contract is not valid. So I think that it's a step too far that the court's taken, in my opinion. Alex, I know, has a bit of a different one, but in my opinion, I think that it's
your opinion is more in favor of employers, which is good, and maybe one day, if you encounter this situation, you'll be a successful advocate. But I really think, that we can kind of change the law, because that's how it's the Ontario Superior Court of Justice, but there's higher levels of court. There's the Court of Appeal, and they're the ones that's the decision we're going to talk about, which is actually more important for employers. But I'll just make the point that I think it is kind of a logical, it's been progressing, right? The courts are getting increasingly skeptical. And again, they're always looking for reasons to find that the termination clause is unenforceable, rather than trying to find a justification for upholding it, because of that power imbalance between the employer and the employee. So I think this is actually kind of a logical extension of what the law was before. It's always been a law that at the time, what's important when it comes to interpreting termination clauses or clauses that seek to restrict the entitlements of the employee, that the court is going to look at the potential violation. Right.
But there's a line that was crossed. The line was crossed because how is there this potential that he'd be in a completely different role without the possibility of a new contract? We can't like. I know that there's the far-reaching implications that the court always looks to. What is the future impact? But there's a line that I think they just stepped over a touch, and I just find that it was too aggressive of a stance from the court on this topic.
There's the potential that there wouldn't be a new employment contract, right? At the same time. But I hear you. A lot of the plaintiff lawyers, employment lawyers who represent mostly employees, I think they would have a different view than you, Rosalie. Certainly. But I think based on what I'm hearing in terms of the chatter of the employment law bar, particularly those who represent employers, they're also not happy about this decision and don't necessarily agree with it. So we'll have to see. This is the first kind of decision that has taken it to that extreme, as far as I'm aware of, and we'll have to see how it plays out in subsequent decisions. There is now a precedent for that. But I think it just kind of illustrates the principle that you have to be very careful when drafting an employment contract. you want to, and the importance of getting your employment contract reviewed, because there are ways of drafting it. If the employer in this case simply said you get your Employment Standards Act minimum entitlements and left it at that without writing, by the way, you're a construction employee and you get, and therefore you actually aren't entitled to any notice of termination or termination pay or severance under the Employment Standards Act. If they just left it at you would get the minimums. Arguably, that would be an enforceable.
Yes.
So sometimes, like we have to, as lawyers, try to think about the future and draft it very carefully. And it's a thinking exercise, but and frankly, our job is to sort of predict the future, but we're not fortune tellers, and the law changes. I think that is a good jumping point for the more seminal case at the Court of Appeal that was released in June 2020, and this is the Waxdale decision. So, Rosalie, before we get on the impact of the decision, on the enforceability of termination clauses, and again, the bottom line is employers, get your employment contracts reviewed by a lawyer as soon as you can. But let's dive into the facts of the case a little. So, Rosalie, what is this case about?
So this case is essentially, your theoretical run-of-the-mill wrongful dismissal lawsuit. The employee was 42 years old. He worked for 8 months, relatively a short period of service, and was a director of sales. And he was terminated on a without cause basis and was given 2 weeks of notice, which was in accordance with his employment contract. So the employee sued for 6 months of notice, even though he only worked for 8 months. So, there was an enforceable without cause termination clause in the contract, and it said that he would be getting 2 weeks of pay, which he got. So there was also a just cause termination clause, which basically said, and I'll explain later, about that, but basically said that he would be getting nothing if he was terminated for cause. And, they didn't go into specific details about what the clause said at the time because it was very specific, and everyone agreed that it was not an enforceable clause.
So the employee in this case, so those are the basic facts, but the employee raised an interesting and somewhat unique legal argument, one that we haven't seen, I don't think, in a published decision, didn't he?
Yes, he did. The employee actually argued that the 2 distinct and separate clauses that were written in 2 different paragraphs in the contract should actually be read together because, and with that argument, he said they should be read together, and because the just cause provision was unenforceable, so too should the without cause provision be unenforceable. So he said that, anything dealing with termination would therefore be enforceable. It didn't matter which, clause he was terminated under, whether it be the without cause clause or the just cause clause. Both of them should be read together, and they would therefore be unenforceable. So the lower court disagreed and followed the usual, situation that we know as employment lawyers, which is the clauses are not read together. If you're terminated under one, you follow that one, and if that one's unenforceable, there's an issue. But if the other clause is not, is unenforceable and they weren't terminated under it, that doesn't really matter, right? It's really the clause that you're terminated under, that's whether it's, the issue is whether that clause is unenforceable or not. So
basically the court, because they thought, or it was not, there was no argument that the employee was terminated without cause. The lower court, at least, was concerned with the enforceability of the without cause provision, because that's the clause that the employee was dismissed under. So as long as that clause was enforceable and met the Employment Standards Act minimums, the employee would get his the contract is enforceable.
And it was, yeah, so that clause was enforceable. So the employee didn't like that answer. So he appealed to the Court of Appeal. And the Court of Appeal basically said that they thought that the statements by the employee were proper, which is, you know, a very seminal statement by the court to make. So they basically said, you know, the contract needs to be read as a whole. These clauses, no matter where they are in the contract, if they're, you know, the termination without cause clause is at point 7 and the termination for cause clause is at point 22, it doesn't matter. They have to be read together. And if either of the provisions are not in line with at least the minimums of the Employment Standards Act, they're unenforceable, period. And that was the decision.
So, other than the fact that the court has affirmed that the employment contract needs to be read as a whole, and it doesn't matter that you have just cause in one place in the contract and without cause termination in another part. Other than that key takeaway, I think another key to this decision was the just cause provision. Rosalie, basically every employment contract that has crossed my desk that has a termination provision has a just cause provision. Hasn't that been your experience as well?
Yeah, the same with me and most. And prior to these decisions, that's what we would recommend to employers. And that's what we would review when looking at employees' new contracts for when they started or at termination for their entitlement. So either side of the coin, we usually would say, you know, if the just cause provision is proper in line with how we would understand it previously, you know, it all checks out and they're in every contract.
Almost, virtually. I would say 90. I'm struggling to think of an example where there is a termination provision prior to this decision that didn't mention just cause. But it's important to note that most just cause provisions as written are probably going to be unenforceable. Why? Well, because just cause is a common law concept. Remember, we talked about common law notice. Common law is basically judge-made law, the law that has evolved through the release of decisions and case law, such as this important Waxdale decision. So that's kind of clarified what the law is. So just cause, again, common law concept. And an employer is not required to provide common law notice of termination or pay instead of that common law notice if they have this just cause to terminate. So what is just cause? Well, it's not as straightforward a question as you would think. Before an employer terminates an employee, regardless of the circumstances, but particularly if they're going to try to allege that they have just cause, that's something that you should check with a lawyer because it's a very high standard. Given that you're depriving the employee of their usual entitlements. So
there was a decision that said that terminating an employee for just cause was akin to capital punishment or something like that. Very, very...
right. It's a capital punishment in employment law. That's a good way of putting it. So that's why the courts do hold it to such a very high standard. It could include things like workplace theft, workplace violence, fraud, sexual harassment, maybe even egregious off-duty conduct that could be damaging to the employer's reputation, insubordination, frequent absenteeism, and then in some cases, repeated performance issues and just incompetence when the employee is given plenty of chances to try to rectify the issues. That might qualify as just cause. But here's the issue. Rosalie, the Employment Standards Act in this province, in Ontario, it doesn't say anything about just cause, does it?
No. The regulations to the ESA or the ESA in general does not use the term at all, just cause. So again, it's been a judge-made concept that we've poured it into our contracts, but this decision particularly points to the issues that, there's two fighting concepts, the common law and the ESA. They usually work together, but this decision has sort of parsed them out. And it says in the ESA, the regulations say that there's only certain circumstances where they're not entitled to termination notice or pay in lieu of notice, which is not the same as just cause. They say that, only an employee who has been guilty of willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer, that only then are they not entitled to termination pay or pay in lieu of notice or the like. So the impact of this decision basically says if you have a just cause provision in your contract, you should really speak to either of us or Jonathan to get them reviewed, because they're likely no longer enforceable, right? This is a completely different threshold than what we're used to, because we, most of the time, did not really refer to the concept of willful misconduct, disobedience, etc. that's in the regulations to the ESA in our contracts, because just cause, seemed to make sense and people understood it clearly. So that's that point.
Yeah. So again, the bottom line, good idea for employers, and we encourage employers to have their contract reviewed, both before presenting, if you're using a template that an employment lawyer has developed for you before this decision was released in June, or at any time. It's always a good idea to get your employment contract reviewed anyway, but especially now, because when you're contemplating hiring, and I know a lot of employers are not contemplating hiring and are contemplating doing the opposite right now, but in the event that they are hiring, you would want to make sure that the contracts that is proffered to these potential new hires is written in a manner that is enforceable in light of this Ontario Court of Appeal decision, the Westdale decision.
Yes. And to that point, this isn't just something that impacts new employees. And that's important also for us to note, is that, your contracts for your employees that you already have need to be looked at as well. And there is a way for us, and we're not going to tell you right now, so let us know if you'd like to get that information. Give us a call, send us an email. We're happy to review your contracts of your current employees. But there is a way that's very simple for you to basically roll them over onto these new amended and proper contracts, so that you won't be liable for common law reasonable notice. So we're happy to help you with that as well.
We are, and Rosalie, you make it seem like it's a secret, but the reason that that we're not kind of explaining this is it's particular for each employee. The process involves us assessing basically the circumstances of your workforce, and then coming up with an appropriate strategy to seek to transition your existing workforce onto new contracts. It can be done in several ways, but it needs to be particularly tailored to your workforce, which is why to actually achieve that, you should be doing that in coordination with an employment lawyer such as ourselves. But yeah, we're here. We're employment lawyers, so yes. And we're always happy to help employers navigate issues such as employment contracts and updating them so that they're enforceable, and helping employers navigate all the other issues that are arising in these challenging times.
Yes.
So again, you can find our contact information on www.knblaw.com. Not only our contact information, but we're pretty much a full service firm that does family law and provides basically support in every aspect of business. So you can find our colleagues in different groups, law groups, contact information on there as well. And after, I'm not going to display all of the lawyers' contact information. That's going to be found on our website, www.knblaw.com. But as we sign off here, we'll have our contact information displayed on the screen so you can reach out to Rosalie myself or our lead of the department of our group, Jonathan Borelli. So thank you so much for joining us, and stay tuned for our next recorded webinar. There are a lot of important developments happening, and the law is continuing to adapt and faster than ever in light of the COVID-19 crisis. So we'll be back soon for another discussion. What the topic will be is we'll find out probably. There might be a new development next week, and then we'll have to adapt. And as we digest that information quickly, we'll share what we've learned with our viewers. So Rosalie, see you next time. And thanks for the discussion.
No problem. Have a great day, and everyone enjoy the heat wave that we're having right now. Okay.
All right. Bye, everyone.
Bye.